to view this ESSA webinar on the Homeless State Plan. We would greatly appreciate you providing feedback by using the guiding questions document that was sent with this link and is also on the ESSA page on the OPI website. Please send your feedback to the email address that will be listed at the end of the webinar. The duties of the State Homeless Coordinator have been clarified under ESSA. First, the State Homeless Coordinator must have the capacity to carry out all of the duties as required by ESSA and cannot serve as the state foster care point of contact. The duties of the State Homeless Coordinator now include the monitoring of all LEAs, including those who do not receive Title I funds. The State Homeless Coordinator is also responsible for developing and implementing professional development opportunities for a variety of groups and individuals, including state education staff, school district staff, tribal education staff, other state, tribal, and local government personnel, and local nonprofit organizations upon request. Technical assistance and advocacy is also provided upon request to any LEA agency, organization, and to individual families and students experiencing homelessness. At the local homeless liaison level, there is also an increased emphasis on the capacity of the liaison to carry out their duties as required under the law. All local homeless liaisons must receive professional development as determined by the state coordinator. Their duties still include identification of students who are homeless and the need to assist those students in accessing free school meals, transportation, and other required services. They must ensure that students identified as homeless have access to all educational services from preschool through access to post-secondary opportunities. The liaison must ensure that information about eligibility under this law, including the rights of students identified as homeless, has been made available to the public. For the first time, ESSA specifically mentions the critical role of school counselors in supporting the educational success of students identified as homeless. The OPI recognizes that school counselors will be key partners in ensuring that high school students identified as homeless are able to transfer credits if they must transfer schools. School counselors should carefully evaluate coursework and collaborate with teachers at both the sending and receiving school to award students full or partial credit for coursework completed at the sending school. Graduating seniors and juniors completing college applications and the free application for federal student aid, the FAFSA, must be given information regarding their eligibility as independent minors if they have been identified as an unaccompanied homeless youth. ESSA further tasks school counselors with the duty to advise, prepare, and improve the readiness of such youths for college. The OPI firmly believes that this task should begin when a student first enters public school, with the goal of preparing all Montana students for college, career, and community. Students identified as homeless have the right to stay in their school of origin. This is the school where they were enrolled when they first became homeless. School of origin rights include preschools and continue as long as the student continues to live in a qualifying homeless situation. School of origin now includes the feeder pattern in which other students enrolled in the same school naturally progress. Placement in the school of origin is always assumed to be in the student's best interest. Districts are required to offer and provide transportation to all homeless students, even when transportation is not normally provided. In Montana, transportation is limited by state law to a distance of no more than 60 miles or no longer than 1 hour. Exceptions may be made on a case-by-case basis. Families and students have the right to dispute a district's decision regarding their eligibility as homeless, the school their child must enroll in, and other services. Districts must enroll and serve a student throughout the dispute process. Districts should be aware that a student's status as homeless is a protected FERPA record and should only be shared for educational purposes. ESSA includes a number of new reporting requirements for students identified as homeless. The state is required to publish data on the state website regarding the number of homeless students identified in each district. This information is now available at the linked address in this PowerPoint. This data is submitted to the U.S. Department of Education in December of each year for the prior school year and will be available after it has been submitted. State-level report cards are also required to disaggregate data on the achievement and graduation rates of students identified as homeless. All Title I districts must include specific information about the services that will be offered to students identified as homeless in their targeted assistance or school-wide Title I plans. All Title I districts are further required to set aside funds to provide comparable services to students identified as homeless. A detailed description of the uses of Title I funds to support homeless programs can be found in Section M of the USED's Education for Homeless Children and Youth Program Non-Regulatory Guidance as amended in March of 2017. The amount of the set-aside should be determined with the help of the homeless liaison based on a needs assessment. The awaiting foster care placement category has been removed from the McKinney-Vento Homeless Education Act. Foster care students are now guaranteed educational rights and services under Title I, Part A of the ESSA. The law covers students in any type of foster care placement, including kinship care, regular foster homes, group homes, and emergency shelters, when the state or a tribe is the placing agency. Payment for care is not an eligibility criteria. The state is required to designate a foster care point of contact. Each LEA is also required to appoint a foster care point of contact upon the request of the local Child and Family Services Division. The OPI urges all LEAs with group homes in their boundaries and any LEA that is aware of foster children residing in their boundaries to appoint a staff member to serve as the foster care point of contact and to reach out to their local Child and Family Services Division office. The OPI is currently working with the Department of Health and Human Services to identify all eligible foster children in the AIM student database at the state level. LEAs will not be responsible for maintaining this information. Students in foster care now have many of the same rights guaranteed to homeless students. They have the right to immediate enrollment without documentation. This includes birth certificates, immunizations, or formal paperwork from the placing agency. Foster care children have the right to remain in their school of origin. This is the school they were attending when they were placed in foster care. School of origin applies to preschools and to the feeder pattern in which other students enroll in the same school naturally progress. A student may remain in their school of origin for the duration of their time in foster care. Placement of children in foster care may be based on a best interest decision. This decision should be made jointly with the caseworker from the placing agency and the school. Multiple factors should be considered, including student safety, transportation needs, attendance issues, special education services, relationships with teachers and classmates, access to extracurricular activities such as sports or band and choir, and access to specialized courses such as career and technical education or advanced placement courses for high school students. Students in foster care have a right to transportation to and from the school of origin. As with homeless students, transportation is limited by state law and cannot exceed 60 miles or 1 hour. Again, exceptions should be made on a case-by-case basis. There are 3 options for paying for the cost of transportation. 1. The Child Welfare Agency may offer to cover expenses using Title IV-E money. These funds are available for approximately 35% of children placed in foster care in Montana. 2. The district may offer to cover expenses using their transportation budget. This can be done using existing bus routes, creating a new bus route, or through an individual transportation contract with the foster family or group home. 3. The district and child welfare agency can negotiate a cost-sharing agreement. If children are reunited with parents or guardians, they can remain in the same school if it is in their best interest. Transportation should be provided until the end of the school year. Title I funds can be used to cover some of the extraordinary costs of transportation, and like homeless, districts must provide transportation even if they do not normally offer it. Please take time to fill in the guiding questions document and send it to Sherry Harlow. Her email is listed on this slide and on the guiding questions document. Analysis of these questions will be reviewed in June and help guide Montana's state plan. If you have additional questions, please contact either Heather Denny or Jack O'Connor.